Hi everybody, I'm immigration lawyer John Khosravi. It's December 29th, our last live video Q&A before the new year. We're going to talk about U.S. immigration, talk about what's going on, and to help you get general education responses about the U.S. immigration system. Wednesday, 6 p.m. Pacific every week. For about 2 years I've been doing this and we're going strong. So if you have questions, tune in, check it out, and we give out free video consultations to the live viewers. So if you're watching live, like and press subscribe, and just write consultation, and my wonderful assistant will name off a person every 10 minutes for the 30-minute broadcast. So 3 live 15-minute video consultations are raffled out to people that are chosen that just participate. So it's a good chance you'll get it. Just participate if you're watching live, and we'll get it throughout the show. We'll announce your names every 10 minutes, or the winners are. Also, if you're interested in doing a marriage case, a fiance case, bringing a green card, getting a green card for your important loved one, just download the Ultimate Marriage Green Card Guide at marriageimmigrationlaw.com. And with that, let's get it started. All right, so we got our questions popping up. Our first one is coming from Adan. Update on F2A. So the F2A category, the family preference second category, is for spouses and minor children of green card holders. What's the update? Very, very bad news. The processing times are getting worse and worse and worse, particularly if you're doing the California Service Center. Usually if you watch the show, you see I don't say any particular service center is worse than the other ones, because they're all, when it comes to time, pretty bad. The California Service Center's estimated times are out of control, and I've been talking to people who are waiting 2 years for an F2A marriage I-130 to be approved. That's ridiculous. Typically for my own cases, 18 months was the most I had seen on an F2A preference case, spouse of a green card holder. But I had to call somebody, 24 months, 23 months or something like that, going on 24. That was out of control. What can you do? We could file a lawsuit for delay. That could potentially work, but it's going to cost money. But that's the news there. And then you have the extra headache of when they go to the U.S. Embassy. When is that interview going to be scheduled? We don't know. So there's just a long waiting. So what I tell clients, and this morning I told the consultation too, is the key is be prepared for a long wait. It's going to take a long time. So what I like you to do is, save your money. If you need money or don't, or whatever money is, use that money to go on vacations where you meet each other. Now I know you're scared of COVID and traveling during COVID, but you have no choice. Try to just visit each other as much as possible so the relationship doesn't get destroyed through this long wait that could take years. It's a travesty. It's injustice for a marriage case to keep spouses separated for this long, I believe. You got to keep suing the government until it makes some noise, talking to politicians, say, hey, these categories for marriage cases shouldn't have these kind of backlogs. Let's fix this up. How can we do that? So that's what I'm just recommending. But that's the situation right now. Thanks for the question. I wish you the best. Adnan follows up, my case at the MBC stage. Okay, so they're no longer at the I-130 stage with the delays I was talking about. You're saying you're documentarily qualified October 2020, and that's the issue. Now you gotta wait for the embassy to schedule an appointment, and we don't know how long that's gonna take. Some embassies are faster, will do it. Some are just closed, they're not even scheduled. It really depends on the individual decision on that embassy, of that ambassador, frankly, of what they want their embassy to do. So in this kind of case, you just gotta wait unless you want to file a lawsuit for delays. That's what some people do. It may work, it may not work. DQ asks, hi, hope you have a wonderful holiday. Thank you so much. I am trying to stay away and not getting hit by this COVID bug. All right, DQ follows up. Let's assume the Build Back Better bill passes the Senate. How is it going to help those who are outside the U.S. waiting for their priority date to become current? Well, I did a show going about Big Build Back Better Act with my colleague Anya Sergeyeva. Check out the YouTube channel, it's there. But essentially, depending on what category you are, they may move the categories forward faster. But practically speaking, because of the delays, there's gonna be a long wait anyways to get an embassy appointment, but potentially your priority date could be moved up much faster. So potentially it could really speed things up, but there's 1,000,001 factors involved. So that's about as general and as specific as I can say. Senior Designer says, good night to you too. Edelanto asks, Mr. Immigration Lawyer, what's taking so long for all the process? Well, there's a lot of different factors. The previous administration sabotaged the system, so it's taking a while. And then we have COVID, closing things down and backing things up. And then we have, not enough staff to handle the cases. When it comes to USCIS, the management issues are really bad. The employees there are unhappy according to the government's own analysis and surveys. So it's a perfect storm of just bad stuff, and so you're going to be caught in these long processing delays, unfortunately. Blue Water asks, if someone's on asylum, can their green card spouse apply for him? Yeah, that's possible. You get your green card through there. I mean, if you already have asylum, you could apply for a green card based on your asylum after a year. Now, I've never had a case where, I have had one where a U.S. citizen spouse applies for the asylee for citizenship, for green card. That was unique circumstances. I don't want to get into here. I never had a green card holder spouse. And the thing about a green card spouse, to be able to adjust status based on INA 245, they have to satisfy certain requirements. So I may or may not be possible. So I'm going to retract the answer saying yes, it's something I have to look into. I also need to review the background of the person at asylum. So I'm not positive. I need to review it. If the green card holder spouse was a citizen, then yeah, it shouldn't have been a problem. But with the green card, I don't know. Plus, there's the issue of you're admitted or not. Just the long story short, Blue Water, I need to research that question with your background and facts before I can answer that. There's a lot of little things that pop up that can be problematic. Most likely in these kind of cases, we'd say, why don't you just adjust status based on your asylum rather than go through the headache of having your green card holder spouse do it. But if you'd like to schedule a private consultation, we can schedule a time on that. Ida Antonio asks, can an immigration lawyer sue the government for taking too long to get back with processing times? Yeah, they do it frequently. Now, you don't need an immigration lawyer per se. You need a person who litigates, sues the government. There are immigration lawyers who do both, and there are people who just do lawsuits on their own. So my office, I don't do lawsuits, but there are a lot of people who do them. But for certain delays, yeah, it's inappropriate. You sue under the Administrative Procedures Act, the APA, saying this is a capricious and ridiculous kind of waiting, and sometimes it works, sometimes it doesn't, but it's an option that many more are using nowadays. The number of lawsuits over this issue has gone up like tenfold in the last couple of years. Deco follows up, my son's visa category was under F2A. I made a mistake by becoming a citizen. Now he's under F1. Will I lose the earlier priority date? Will they give a new priority date? No, there is a rule under the Child Status Protection Act, CISPA, CSPA, that says if you are F2A and you naturalize, you could maintain the previous category that you're in. So you could contact the U.S. government about it and say, I want to remain in the F2A category, so we get the earlier priority date. And for those who don't know, for some reason, it's kind of weird, cases of adult children of green card holders is 1 year faster than cases of unmarried adult children of U.S. citizens. So the F2A or F2B, I mean, the thing is, Deco, the question, first of all, Deco, you're a raffle winner, so we'll talk about this in private. Just take a screenshot of where you're watching this and email it to me. I'll schedule a private consultation. But if the child was F2A and they're under the age of 21 still, and you become a citizen, the case turns into an immediate relative petition, not an F1. If the kid has aged out in some way, they have a rule on this, whether you can still be immediate relative or not. There was a certain case on it that recently passed. I forgot what the exact rule is. But they may still be an immediate relative. Now, it's not an F1. But one way or another, they could keep their priority date, and that's that. Antoine asks, I filed Form I-751 probably after divorce. What kind of evidence am I going to need? You need all the evidence. You got to show your relationship was real. So what kind of evidence? You know, all the stuff that you have in your relationship. Did you join bank accounts, credit cards? Did you have property together? Did you have lease agreements, car insurance, a car, health insurance? The insurance that when you die, what is it called? Death benefit insurance, whatever, I forgot the name of it is. There's just a lot of things. Did you have a lot of mail coming to both houses? Did you have Amazon account together? Photos together, travel history together? You just got to dive deep in your relationship and see what you had to show that you're doing regular couple stuff and the relationship just didn't work out, and then fight it out. FQSR asks, does a person have probation? Can he apply for citizenship? You can apply, but your case is going to be denied. So if you have active probation, they will deny your citizenship case. You have to have that cleared out before you can apply for citizenship if you want to get it approved. Can an EAD holder, green card EB3, be a financial sponsor on a case where a U.S. citizen is wanting to sponsor a spouse but doesn't meet the income requirement? No, to be a financial sponsor for an affidavit of support, Form I-864, in a family-based category, preference category in particular, you have to be a U.S. citizen or a green card holder. As a non-immigrant or whatever category you currently are, that has an EAD, you cannot be a financial sponsor yet. So we get your green card first, then you can do it. Noah asks, can a U.S. citizen travel to the U.S. on an alien passport if U.S. passport expired? No, technically, if you're going to enter the United States and you're a U.S. citizen, you have to enter with a U.S. citizen passport. Now, CBP can do whatever they want. I had a person who accidentally forgot to bring their passport and only had their foreign passport. And upon entry, CBP, the Customs and Border Protection, the people that run the airports and the land borders and stuff, took a while to go in the system, look up the person, verify identity, all this kind of stuff, and they let them in. But technically, you're supposed to come with a U.S. passport, but they can make exceptions at the end of the day. If you're a U.S. citizen, they can't really like not let you in, but that's about it. Simon asks, hi, I'm on OPT. It expires in June 2022. I am marrying a green card holder in January. Okay, let's back it up. I'm on OPT. OPT is a special optional practical training. It lets people who are on a student visa work in the U.S. for a year after graduation so they get on-the-job experience. And it's expiring in 6 months or so. I'm marrying a green card holder in January. Can I apply for the I-130 and I-45 together because my visa expires and processing times are long and I'm worried about losing status? Yeah, I mean, I can't tell you exactly what to do in your case because I need to review it. But generally speaking, if you're in status and you don't have violations or something like that, right now the visa bulletin for the F2A category, spouse of a green card holder, is current, so you can file the form I-130 and I-45 concurrently. That's what the technical term is, but together essentially. And then you just stay in the United States even after your OPT expires, waiting for the final interview and approval. And in the meantime, with that, the sooner you apply, the better, because you can apply for a work permit on it too, so you can continue working. But it's going to take 6 to 10 months to get a work permit. So the sooner you get married, the sooner you file for adjustment of status and file for the EAD, the work permit, the sooner you get a work permit to hold you over after your current OPT expires. So heads up on that, but definitely download the Ultimate Marriage Green Card Guide at marriageimmigrationlaw.com. I think this will be very helpful to explain the process, get to know it better. That's going to be important. But check that out. But thank you for your question. And Salma, congratulations on getting married. A wonderful decision in the new year. Mohammed asks, do we need to submit passport photos of the N400 application? No, it's not a requirement for naturalization, a citizenship application, to submit passport photos anymore. They stopped doing it a couple years ago. Some field offices say if you're going to change your name, they'll want 2 passport photos. So if you are doing a name change, you get it. And some officers just make it up, saying we need 2 at the interview or something like that. But if you're not changing your name, I don't submit passport photos unless people are changing their name. That's the rule I go by now. And that's that. So if you're not planning to change your name, you don't need to send passport photos with the N400 application for naturalization. One for Kind asks, can an RFE be extended or submit documents without requesting past deadline given? Unfortunately, USCIS can do whatever it wants. If you request a hardship or something like that, who knows what it'll do, but typically it's very rare for you to be able to submit documents after the RFE period has ended. Now, because of COVID, they have given a 60-day extension from the RFE period. So let's say your RFE is a request for evidence. When you've submitted a petition or application to USCIS and they find there's something missing, they'll give you typically 87 days, sometimes 30, but sometimes 87 days to respond. Because of COVID, you get additional 60 days plus that 87 to be able to respond to it. So you may have more time, so you may just not be past the deadline. But typically it's very hard to almost impossible to submit it. You'd have to redo your petition because they'll be denied. Hopefully you could take advantage of 60 days and it's not that bad. 14 months documentarily qualified and still not getting an interview. Yeah, unfortunately that's what I'm seeing. 14 months is the longest, but I don't have anything really. So what he's talking about is it's a person who has a green card petition pending. They completed the National Visa Center part, and the case is moved on to the embassy, but the embassy is not scheduling the interview. Omar, which embassy are you dealing with? That's the longest I've seen. I have cases that are 13 months now, but 14 is the worst I've seen it, where the embassy is just not scheduling an interview even though everything is ready to go to have an interview. This is just the travesty and just the horribleness of what's going on if you're doing consular processing. It's not that bad if you're doing adjustment of status, if you're in the United States, but if you're going through Department of State, the consular processing embassy system, it's not clear when your interviews will happen. So that's why when people, a lot of times they say, how long does this take, how long does that take? This gentleman, Omar, 14 months waiting for an interview, still not being scheduled, and we have no information, notification of when the interview is going to happen. And that's why when people ask how long this is going to take, it's impossible. I can't predict the future. It's like asking, when is COVID going to end? We don't know, and that's apt because COVID is directly related to a large part of the delays because the embassies don't have enough officers and not scheduling, and they're not going to pretty much do it until they feel less afraid to come to work and restaff and all that kind of stuff. So you could try filing a lawsuit. I did that to one case and the government's fighting it, but that's about it. Rosemary asks, I received my approval notice yesterday for F2B category from Jamaica. How long does it take before my embassy will send a welcome letter? Does my priority date have to be current? Priority date is 2017. I don't know the F2B category times right now to look it up, but you know, a year or so, or you have to look at the bulletin. They'll notify you, they'll email you when it's time. But I don't know the priority dates off head for F2B category. You can check out the visa bulletin, they'll talk about it. They'll email you before your priority date is current to let you know to get started. But it depends on whenever they want it. Sometimes they send it really early, sometimes late, but before your priority date is current for the final action date, you should be getting the welcome notice. But I'm not close enough to your case to be able to answer that and have to like look into it and stuff. Thank you so much. God bless. Be safe. Happy New Year. I'll see you all in 2022. Bye-bye. I hope you enjoyed this educational video. You'll find our social media site has a lot more videos, images, and information about the U.S. immigration process. Please check those out on the various social media websites.